Hello viewers and the students. Today we shall discuss a new subject, that is Sale of Goods Act 1930, in which sale and purchase of goods are discussed, and so many things are read in this subject. First of all, sale is there, then goods. What are the definition of goods? Which kind of goods are called goods or property called goods? These things. Now, we can start from the sale. As we know from past experience that the transaction of things between the parties is taken place, then there exists contract. As we know from past experience that contract is nothing but transaction between the parties of act or transaction, act or many things included in the contract. So far as contract is concerned, as we know, there must be two parties and parties must be competent. In this regard, in case of sale also, parties must be competent with regard to the transaction of the matter which we are going to be discussed. Now, about the sale, many courts and finally the Supreme Court has made its verdict in the famous case Coffee Board Karnataka versus Commissioner of Tax and others, AIR 1988, in which the court has given its verdict and opinion and direction that in the sale, four things are necessary to be included in the sale. First, in the case of sale, there may be at least two parties which must be competent. Now, next thing is very essential is that there must be reciprocal consent between the parties. These are the also essential parts of the contract. So, in the sale also, these two essential elements must be present in the sale. And next is transfer of property must be there in terms of goods. And finally, cost of the transaction must be in money. So, sale includes subject matter like goods, and goods is nothing but it is a kind of property and property of movable property. So, let us see that in the sale, the transfer of property is done, but not the property which is which is discussed in the Transfer of Property Act. But sale of goods is there, and here the property is also there, but movable property is there. Now the question arises, what is movable property? Then we can say that the property which is easily have the silent feature of displacement from one place to another place, and this is not a kind of displacement, and such a property is called movable property. But the timber of the timber is not meant for a movable property, and at the same time, sometime it means the timber is supposed to be the movable property, and the crops and grass which are rooted in the earth is also said to be movable property, except the property like action, claimable action, actionable claim, and the debt. Except two things, every movable properties are said to be goods or included in the goods. Now, the goods is or are also many kinds, in which some of the example may be quoted as existing good, अर्थात वर्तमान माल, future goods, भावी माल, contingent goods, समाश्रित माल, specific goods, विशिष्ट माल, and lastly uncertain goods, that is अनिश्चित माल. These are the kinds of goods which are included in a movable property or which are said to be goods. Now, sale or contract to sell, two things are very vital to know about them. Now, the definition of sale is said to be a transfer of ownership from buyers to seller. Seller to buyer. And this type of transaction and transfer of ownership is considered to be or said to be sale. Like a contract, seller is promisor and buyer is promisee, and between them subject matter of transaction is goods, wherein ownership of goods is said to be transferred. Now, if sale is concerned, then to make compare with the contract, then sale is a kind of executed contract, whereas contract to sell is a executory contract. Executed contract, as you know, the contract which is or which has been executed by promisor to the promisee. But in case of executory contract, there is yet to be done or yet to be finished or yet to be executed, then such a contract is called executory contract. The contract which is yet to be executed. Similarly, in the case of contract to sell is also there. When the ownership of a goods is yet to be transferred, is nothing but a contract to sell. Means the sale is broken sometime or in course of future when some conditions yet are to be fulfilled by one party to another party. In many cases, buyer has to fulfill the condition given by the seller with regard to the goods. So, the seller and the buyer has liabilities in their own part, and both of them has to make their reciprocal promises. Then only transfer is taken place, and transfer of ownership is taken place, and the contract is said to be finished. Now, the essential elements of sale is concerned, we can say that, or it is easily to say that, first essential is that in the sale, two parties, that is, seller or buyer, must be there. They must be competent. Means the seller must be competent as well as the buyer is also must be competent. Then only the sale is said to be finished, said to be said over. Now, what seller does? Seller sells the goods and the purchaser, that is called buyer, takes the goods. There may be chance that ownership is changed in the course of sale, but possession still may be either with the seller or after in future he can take the possession of the goods. Now sometime the seller becomes unpaid. In that circumstances, he can lien the goods or the property in his possession until unless the buyer pays the rest amount or whole amount as the case may be. Now, next essential element is that the subject matter of sale of goods in goods must be only of property, and property must be movable property, and that is called goods, and nothing else. Now, third essential element is that the cost or transaction must be taken in the terms of money. Now, the sale is said to be finished when the transaction is taken place or transaction is over. A case in this regard means sale is also given in this regard, like East India Hotels Limited versus Union of India 2001, in which it is expressed in this case that when a person visits the hotel and he gives his order by observing the list of the kinds of foods, and after giving order he also pays the amount which is yet to be paid. And so now if he does not take his dinner or food in the hotel, and this transaction is also said to be sale. But in case of circumstances when a sale is not said to be sale, like an example I can say, quote you in the terms of a Supreme Court also, that a case came to Supreme Court of India and its decision was given in 2009, and that case is Government Medical Store Department versus State of West Bengal 2009, in which the central government has given medicine to his own department in the West Bengal, and so the central government was of the opinion that what he had done or acted is nothing, or transacted is nothing but a sale. Court says no. There was no any transaction made in that regard. When central government gives medicine to its own department or medical department or government department, there is no question of any transaction, and there is no any existence of contract between them, because there was lack of essential element in the existing contract, because government and its department or medical department is no two persons or different persons, and the court given its opinion that both of them are the same thing, and the government medical store is working under the central government or West Bengal, central government or state government. So there is no need of any contract, and so there exists no contract. In this way, we can arrive at the conclusion that the sale has its essential element with it, and without finishing the essential elements and fulfilling the essential elements, the sale is not said to be complete, and there is no question of sale. Now question arises, what is the difference between sale and contract to sell? Now note it, I am to start with it in Hindi. Now the first difference between sale and sale to contract is that transferability of ownership means in Hindi स्वामित्व का हस्तांतरण. As we have discussed earlier before you that in the sale transaction is being done, but only ownership of the goods remain transferred. Now in Hindi it is expressed जहां तक विक्रय का संबंध है इसमें स्वामित्व का हस्तांतरण तुरंत होता है, परंतु विक्रय का करार में स्वामित्व का हस्तांतरण भविष्य की तिथि तक होता है या कोई किसी तरह का यदि शर्त है तो शर्त को पूरा करने के पश्चात ही ओनरशिप का ट्रांसफर होता है. दूसरा दायित्व रिस्पॉन्सिबिलिटी. जहां तक विक्रय के संविदा का संबंध है इसमें वस्तु का अधिकार क्रेता को अर्थात बायर को पूर्ण रूप से हो जाता है. इसके विपरीत विक्रय के करार में केवल तथा क्रेता तथा विक्रेता दोनों के लिए कुछ अधिकार का उदय होता है. दोनों में से जो भी उसका उल्लंघन करेगा उसी पर वाद प्रस्तुत किया जाएगा. नेक्स्ट पॉइंट जोखिम या रिस्क. It is the principle of property that when the property is transferred, then it is said that risk passes with the property. In this regard, in Hindi, विक्रय के तुरंत बाद वस्तु क्रेता के पास आ जाता है, अतः क्रेता के ऊपर ही जोखिम आती है. इसके विपरीत विक्रेता करार के समय वस्तु विक्रेता के पास रहता है, अतः जोखिम भी विक्रेता को ही उठानी पड़ती है. इस प्रकार आगे भी इस संबंध में कुछ हम बात करेंगे.